A presentation on the pitfalls of legal recognition in the context of Indigenous land claims, whether this ongoing history of colonial violence, as I described it, really amounted to appropriation. I was baffled by the question, but I think what it prompted was the desire to think about appropriation in the fullness of the meaning of that term. What does it mean to appropriate land, water, and other resources that are not yours? And what does that do to the modes of governance, ways of living and reproducing life, ontologies, cultural practices, and so on that subtend those relationships to land? The history of appropriation of Indigenous land on a global scale could not simply be read as a series of legal justifications for the theft of land that was motivated by a particular form of capitalist development. Nor could it be read simply as the result of European racism that held, certainly from the 19th century onwards, Indigenous peoples to be inferior to white property-owning Anglo-Europeans. Rather, in order to understand the fullness of the mode of appropriation that informed settler colonialism in places such as Canada or Australia or Palestine, one needed to, embracing Cedric Robinson's concept of the racial regime, look across domains of science, economy, cultural production, philosophy, and law to understand the processes through which First Nations territories could be transmuted into crown lands to be granted to settlers, or to understand how the racial logics that emerged with and through the legal form of property were rooted in ideologies and economies of thought that were forged in conjunction with one another.